the court must enforce the limits of power as enforced by our Constitution. My Lord, I have something I would like to put to you as an officer of this court. When public officers come before the court, don't they have a duty to be impartial and to actually give the court, to the best of their ability, the issues as they are? And to that extent, can the IEBC come to court to protest on the issue of quorum, knowing very well that they are not fully constituted, knowing that the steps to fully constitute them are under the way? Should they waste public funds, public resources, time and money to come and contest such an obvious point? Should the AG, who ought to have advised the executive and the government to replace the commissioners who resigned immediately, should they waste public resources coming to canvass this point before the court, or should they have considered and said the work is underway? Can the IEBC contest the issue that there is no referendum law, the IEBC and Parliament, yet there is a referendum law pending now before Parliament, meaning that they have already identified there is a gap and they are working to redress it. Yet we hear the Parliament and the Attorney General canvassing, not the Attorney General, but IEBC, canvassing this issue before the court. Is this prudent use of resources? What is the court's role in this? Is this a case where the court should reprimand those officers, those state officers, and even ask them to bear the costs? It is happening too often, where state officers take Kenyans who question as their enemy, instead of serving them equally with others. These are the questions that are before the court, and I dare say they demonstrate the impunity which permeates ranks of state officers, the executive, very much of government. We are asking the court to utilize that sword to slay the monster. Parliament delayed the appointment of those commissioners by not passing the law. Can they use their delay to come and ask the court to find otherwise? These are the questions we are asking. We urge the court to dismiss this appeal and to affirm the judgment of the High Court. I yield to my learned junior, Muthoni Nyuguto.
Try to demonstrate how it is it's impossible for all the steps of public participation identified by the learned judges in the Superior Court for public participation if we are to allow Wanjiku to be the one to drive the popular initiative. We disagree with that view because, and I heard Senior Counsel Tindo Molo exemplify and ask the court to reflect on whether, for example, Wanjiku can have the bill published, I don't know, in the national languages, the national language, which is Kiswahili, the official languages, which is English and Kiswahili, the vernacular or indigenous languages, and so forth and so on. And he said if we submit Wanjiku to this kind of procedures, it will not have been possible, and I hope I'm not misquoting learned Senior Counsel. Our view is that this demand, this 10-step process demand, was not the invention of the learned judges in the Superior Court. It is a dictate, a requirement of the Constitution in Article 7 of the Constitution, which the learned judges relied on, which calls on state organs and state processes to for example, use the languages and even try to promote indigenous languages and the use even of Kenya Sign Language and Braille where possible. And when it comes to the technical side around Braille and Kenya Sign Language, the Constitution is considerate and uses such terms as promote as opposed to demanding outrightly that that must be done. And therefore, on this public participation, it is a demand of the Constitution. Secondly, on the same theme, it is our submission that both the popular initiative and the parliamentary initiative must therefore be
also good for the cattle rustler in Baragoi, and it's very good for the beach boy in Watamu. These are the people. These are the wananchi. Not a person bearing the titles Honorable or His Excellency. Any person bearing the titles Honorable or His Excellency, purporting to be the people, mwananchi, is a sheep, is a wolf in a sheep's skin. And my Lord, a special invitation to this court is this. There has been conflicting submissions on who the promoter of the bill is. On one hand, the Attorney General, in his submissions at paragraph 69, says that the initiative is the BBI initiative, a voluntary alliance of political parties. That is the description. But they come before here, and there have been conflicting narrations of who is the promoter or who is the initiator. To that extent, the exact finding that I'm asking this court to make is this: whether the appellants have approached this court with clean hands to warrant upsetting the decision of the High Court. That is the question. Should you find that the conflicting decisions, submissions they've made, then they do not warrant the overturning of the decision of the High Court. My Lord, this shift reminds me still of the words of Chinua Achebe in his book, Things Fall Apart, when he narrates about one character called Okonkwo. And Okonkwo writes like this and says like this: when I hold her hand, she says, don't touch. When I hold her foot, she says, don't touch. But when I hold her waist beads, she pretends not to know. The question is, my lords, that when you hold the waist beads of the appellants and ask them, who is the initiator of this proposed bill, they pretend not to know. That is the finding, my Lord, that I want you to make. For my Lord, the question is that where the court holds, the question is, my Lord, that the principle of constitutionalism would behoove this court to start like this, that expressio unius est exclusio alterius. To what extent am I saying this, my Lord? I make reference to our document, a bundle of authorities. The Supreme Court of Rhode Island, in the Constitutional Convention of 1883, found at page 887 of volume 2, stated this to that principle: we are of the opinion that the mode provided in the Constitution for the amendment thereof is the only mode in which it can be constitutionally amended. The ordinary rule is that where power is given to do a thing in a particular way, there the affirmative words marking out the particular way prohibit all other ways by implication, so that the particular way is the only way in which this power can be legally executed. My lords, and my ladies, on to my first point, whether this court should order His Excellency President Uhuru Muigai Kenyatta to refund the public monies used in the unconstitutional constitutional process. My lords, on this is a novel issue for the following reasons. No court in Kenya has made a determination on Article 226(5) of the Constitution. In the whole of Africa, South Africa in 2018 is the only democratic country that ordered His Excellency, President Jacob Zuma, to refund approximately 1 billion shillings used in construction of his house. That was the taxpayers' money. And my lords, the history of the erstwhile Constitution of Kenya, with its 6 provisions on public finance, never provided for a provision akin to Article 226(5). And for that reasons, my lord and my ladies, the High Court's findings and declarations at paragraphs 784 to 785 of their judgment, respectively, were sufficient for an order to make good the loss of public funds. No evidence was needed for that order to be made. No evidence. It is strict liability. No evidence was needed. And if any evidence was needed, it was the evidence in the special knowledge of the appellants. Section 112. He who